So, friends, I am thrilled to have my friend Kimm Wehle with me here today on Justice Matters. She is a tenured law professor at the Baltimore School of Law. She is a renowned constitutional law expert, a separation of powers expert. She's an ABC News legal analyst. She's also served as a federal prosecutor. And importantly, she's the author of three great books and another one that literally could not be more timely. They are How to Read the Constitution and Why, What You Need to Know About Voting and Why, How to Think Like a Lawyer and Why. I love that Kimm's books are not just how-to books, but why to books, why these matters are important for, the health of our democracy. And her upcoming book, which literally couldn't be more timely given what we are now contending with in the aftermath of this new Supreme Court opinion. And it is titled Pardon Power: How the Pardon System Works and Why. And it will be out on September 2nd. So, with that, let me welcome our friend Kimm back to Justice Matters.
Great to be here, Glenn. Always such a pleasure to talk to you and to your listeners.
All right, Kimm, if I could ask you to start by just giving our viewers a sense of your top line takeaways or concerns regarding the new Supreme Court opinion in Trump versus United States.
Well, hyperbolic is, I think, an important footnote. This might sound hyperbolic, but the Supreme Court basically rewrote the foundational concept of government by we the people under the United States Constitution. That is, the Supreme Court held that one of the three branches of government has essentially license to use the massive powers of the federal government to commit official crimes using official power, and there's no accountability through the criminal justice system. So this really is rewriting the foundational separated powers of the Constitution. No more kings. There's not one branch that has all the power. A Revolutionary War was fought over that. People died. Blood was shed in the streets so that we could throw off the yoke of a monarchy where there is no checks and balances because the power came from the divine. After 237 years, the Supreme Court, who is unelected and does not have this authority under the Constitution to amend it, essentially turned our three-part system of government into one in which there's a single person with unlimited power to entrench their own power.
You directed me to a piece that was written by one of the preeminent constitutional scholars up at Yale, Akil Reed Amar, and I instantly read it after you recommended it to me. And I wonder if you agree with his assessment. I know I do, that essentially it's like the Supreme Court amended the Constitution. And then I think he kind of finished up by saying the Supreme Court declared that the Constitution, at least in part, is unconstitutional, which as a simple gutter kid from Jersey, it's very hard for me to wrap my head around the Supreme Court declaring the Constitution unconstitutional. I was wondering what your take is on those assertions by Professor Akil Amar.
I agree with him, and they did it in a cute way. That is, they didn't come out and say it. He's saying that's his top line takeaway, and let me explain why he is saying that. They essentially said when the president is doing presidential things, the president can commit crimes. And so long as the president is doing presidential things using official power, he can commit crimes, and there's nothing anybody can do about it, at least through the criminal justice system, even when he's a private citizen. The reason Professor Amar said that the court essentially declared the Constitution unconstitutional is in Article 1, which defines the Congress's powers. It has some language in there about impeachment. I know you talked a lot about impeachment. We had 2 impeachments of Donald Trump. The Constitution's really old and it's very short. So every word really matters. It's very terse. And in that provision, and I'm paraphrasing, the framers of the Constitution in 1787, when it was originally drafted, said, if someone is impeached, they can still be investigated, tried, convicted, and sentenced under the criminal laws. Essentially, what the Supreme Court did is take out a Sharpie and cross that part out of the language of the actual Constitution. And these are, quote, conservative justices who claim to live and die by the text, and they just ignored it.
Again, there is a logic disconnect when I know that the Constitution not only says that anybody, including a president, even if he's impeached and convicted by the Senate, can still be prosecuted for the exact same conduct. That's one logic disconnect. And the other, to me, is the constitutional obligation of the president to take care that the laws of the nation be faithfully executed, which in the Supreme Court's estimation means he can violate the laws of the nation with impunity and immunity. Again, that is something I don't understand. To me, when you read the Constitution, it seems like in at least those two places, what they did, the Supreme Court, was they went rogue. It's not an atextual decision by the Supreme Court, it's an anti-textual decision, the way I look at it.
You raise an important piece of Article 2, which gives the president's powers, and that is the take care clause. And I think the word that is important here is faithfully, faithfully execute. What the court did, it used that language and it said, okay, that means you're the top prosecutor. That's what that means to execute the law. You're the top police officer for the federal government and you're the top prosecutor. So when you're exercising those powers, no one can second guess you. The court was explicit. If you're talking to your Justice Department and saying, hey, I want you to investigate, arrest a political opponent, or you're talking to your law enforcement and say, hey, there are peaceful protesters that are objecting to me at Lafayette Square. I want you to shoot them in the leg. That is executing the law, and no one can second guess that. But I think you make a really good point. The word faithfully assumes that means you're doing it within the letter and the spirit of the law. But I do want to make one point clear, just so our viewers can understand how the Supreme Court justified this, but also how it's being covered, frankly, by a lot of people in the media. The Supreme Court said, well, so long as you're using official power, you're immune, President. If you use unofficial power, you can still be criminally prosecuted. So when I say people in the media, well-meaning people are saying, oh, the Supreme Court didn't give absolute immunity to presidents. There still is a space that they can be prosecuted. And so it's being covered as, oh, they kind of went somewhere in the middle. They split the baby. They found a bit for Jack Smith and they found a bit for Donald Trump. But, impeachment, high crimes and misdemeanors is about official power. I mean, you could, I suppose, be impeached for some private conduct, but it's not the private conduct that abuses threaten democracy, right? It's not whether a president lies in a deposition in a divorce proceeding. It's when the president uses the commander-in-chief power of the military in a corrupt way. It's the president uses law enforcement in a corrupt way. It's exactly the official power, abuses of the official power, that the framers wanted to constrain through the separation of powers. What does that mean? It means every branch gets their papers graded by the other two branches and by the rule of law, that no one gets to go scot-free. In making that distinction between unofficial and official, the court got a little bit cute, threw people off the trail, but what they really did was, I agree with Professor Amar, essentially rewrote Article 2 of the Constitution.
And the whole unofficial versus official, the way trial court judges are to figure that out for themselves with very little guidance from this Supreme Court opinion. I'm not even going to get into the sort of new rules of suppressing evidence that they set out in this opinion, which is just bizarre to me. Like we're living in the legal upside down. But there is something that they call presumptive immunity, which has to be overcome by the prosecutor. And to me, the test they set out is going to be very defendant friendly and very difficult for the prosecution to kind of satisfy that evidentiary hurdle. Can you just talk a little bit about presumptive immunity?
Yeah, so a presumption under the law means that whoever gets the presumption has the benefit of the doubt. And so essentially what they're holding is that when it comes to the line between official and unofficial, we're going to assume the president took actions in his official capacity. That's out of the gate. You already have that hurdle to overcome. And then if you want to try to put something in the unofficial bucket, even if it feels unofficial, you prosecutors, to overcome this presumption, have to persuade the judge that if you allow that action to give rise or to produce some kind of criminal investigation or prosecution, it wouldn't affect a president's sort of sense of his presidency. It wouldn't somehow chill his ability to have, the kind of massive power that we're saying he has. So, I mean, you know this better than anyone. It's so difficult, even if there were no presumption, or I mean, that even if it weren't this official, unofficial, overcoming that presumption is so Herculean that it's hard to imagine how that burden of proof would actually ever be demonstrated. And then you have to say, would a prosecutor even bother if there was a crime? Because it's going to be so difficult. And then here's the clincher. The Supreme Court made two kings, really, made the president a king, but also made themselves the king too. Because even if a prosecutor were to say, I'm going to go out on a limb and I'm going to prosecute a president, and overcomes this insane, very difficult presumption with unofficial conduct, the Supreme Court still left open the door for an appeal to go to them, and they would strike it down.
The test that they set out, that it would have no chilling effect. Metaphysically, anything is possible. It could always have some chilling effect. And there are a lot of creative lawyers out there who will come up with arguments about why it would have some chilling effect. It's almost like presidential immunity plus. They really gave very little to the prosecutors who will endeavor to hold just runaway criminal presidents accountable for the crimes they commit in violation of our federal laws in a very real sense against the American people.
I'm just wondering if an example would be helpful for people on this idea of unofficial versus official. So you take the January 6th investigation and the 4 counts against Donald Trump. The Supreme Court said, okay, if you're calling up state legislators and asking them to fraudulently find votes, or if you're calling up a fake electors and say, produce a fake slate of electors for me, they said that might be unofficial, okay? Because state stuff is not within the scope of the presidency. But you could imagine an argument where a president would say, well, but if I can't talk to state legislators, how can I do my job? Because we're a big government, and sometimes I have to talk to governors. So there's one example where then it would be on the prosecutor to overcome that argument and say, no, a president is not going to be chilled in his ability or the sense of I can call a governor or I'll get prosecuted. I just think it's a losing argument for the prosecutor. It's going to be very easy for presidents to basically stick that presumption.
And one of the bright spots here, a little bit of silver lining, which we are always looking for, is that Judge Tanya Chutkan will be the federal judge presiding over these hearings, and she'll have to determine what's official, what's unofficial. And I'll tell you, having known her for decades, I used to try murder cases against her when she was a public defender in the courts of Washington, D.C., and I was a federal homicide prosecutor. I have the utmost regard and respect and confidence in her to do this right, to go hard in the name of justice to the extent, she has the opportunity to do that while still trying to remain loyal to the Supreme Court opinion, which I think will be more challenging for trial court judges than ordinarily remaining loyal to a Supreme Court opinion is. I'm looking forward to these evidentiary hearings. I believe they will be evidentiary hearings. And, I would even call it something of a mini trial on some of these issues. So the people will get to learn about at least some of the evidence of crime by Donald Trump.